today for purposes of the defendant's motion to reduce bond. The court has had the opportunity to review the pleadings that were submitted by both parties, along with listening to oral argument today. I want to point out that the court rule that applies to this case is MCR 6.106. That court rule requires that the court set a bond that will assure the reasonably assure appearances of the defendant for all court hearings, and also reasonably assure any risk and or evaluation of risk to public safety. The factors that the court is to consider are all listed in subsection F of the court rule. Those factors, and they are not mutually exclusive, but those factors include prior criminal history, and in this case, the defendants did have a prior misdemeanor conviction in the state of Florida. Their record of appearances or non-appearances at court proceedings or flight to avoid prosecution, the defendant's history of substance abuse or addiction, the seriousness of the offense charged, the presence or absence of threats, and the probability of conviction and likely sentence, the defendant's employment status and history, and financial history as the factors relate to the ability to post, and facts indicating that the defendant's ties to the community, including family ties and relationships, and lengths of residency. In this case, the court makes the following finding: that the defendants in this case have ties to the state of Florida. In fact, they did reside in the state of Florida, and as the prosecutor indicated, they still have family in the state of Florida. After the charges were issued, the defendants did not voluntarily turn themselves in. Instead, they were found in an abandoned building in the city of Detroit. Their vehicle was hidden to the extent that they were trying to avoid anybody being able to see their license plate. They withdrew a substantial amount of money from bank accounts, and they were not answering attorneys' calls. The seriousness of the charges, I think, is self-explanatory. They are each charged with 4 counts of involuntary manslaughter. So taking all those factors into consideration, the court finds that the bond as set is reasonable and is denying the motion to amend the bond. We will continue to the preliminary examination on February 8th. And at that point, the court will make a determination as to whether or not other days are necessary for purposes of conducting the preliminary examination. Before we disconnect, I do want to have a conversation with all attorneys in a breakout room. So Amy, if you could please put the attorneys in a breakout room with me, please.
Thank you, Your Honor.
Thank you, Judge.
All right, so right there, they are in a breakout session, but you just heard there that the reduce in bond not going to happen there, and you're seeing the reactions from the parents there, and even at times while this hearing was going on, you were hearing just seeing their reactions, and now you can see that they are trying to communicate sign language with each other right now as they are in breakout sessions with the attorneys here. And it looks like an officer has now come to make sure that that won't happen again, but